S.A.
Olayemi.
Yes.
Will I appear for the claimant applicant here?
Claimant. Yes.
My Lord.
Yes, may your lordship be pleased. A.A. Awojobi is my name. A.A. Awojobi is my name. I announce my appearance for the defendants. We are grateful, my lord.
Thank you.
Yes, my lord.
Yes, Olayemi.
Yes, my Lord, sir. My Lord, we have an application for your lordship this morning, sir.
Yes, what is the application?
It's just to regularize our final written address, sir. The claimant's final written address. There were some days out of time.
You are claimant and now you the waste time.
No, sir. It's, sorry, sir.
All right.
No, sir. Your kind, with the kind permission of the court, sir.
Wait first.
Of course, please.
Awojobi.
No opposition, my lord.
Okay, you've been served and no opposition.
Yes, my lord. No opposition.
Okay, that's good. Yes, move your...
My Lord, our motion is dated 18th March 2026 and filed on the 23rd March 2026. A seeking your lordship order, sir, for extension of time within which to file the claimant's final written address. And the order deeming the final written address as properly filed and served, sir. A motion is supported by 8 paragraph affidavits sworn to by one Damulak Mercy. So supported by a written address. My Lord, the view of the fact that my line of friend is not opposing the application and to save the time of the honorable court, sir, we are moving in terms of the motion paper. I want your lordship to grant the application.
Would there be no objection?
Yes, my lord. No objection, my lord.
Court, application granted as prayed. Yes, we move to adoption.
Yes, my lord. Yes, my lord. Yes, my lord. The defendant's final written address is dated the 29th day of January 2026 and filed same date, my lord.
29th January 2026.
Yes, my lord. And filed same date, my lord. We seek to adopt same as our legal argument, my lord.
Okay.
And we urge your lordship to dismiss the case of the claimant. My lord, in reaction to the claimant final written address, filed on the 23rd day of March,
yes,
2026, my lord.
Yes.
The defendant filed a reply on point of law, my lord. And same is dated the 25th day of March. 25th day of March, 2026. 25th, 25, my lord, 25th day of March, 2026. We adopt same as our legal argument, my lord, in support of our evidence, my lord. we urge your lordship to grant our prayers by dismissing the case of the claimants. We are grateful.
Any address in adumbration?
My lord, the defendant, my lord, there's still 2 issues for determination, my lord. The first one is that the suit of the claimant is statute bar and incompetent. My lord, as to that, my lord.
Why is it statute bar?
Yes, my lord. The 11, 16, 17, 19, 23, 24, and 26 of the claimant, my lord, to arrive at the point that the cause of action in this matter arose in July 2013.
But it
July
was filed when?
And it was filed on 21st day of January 2025, my lord. 21st day of January, yes, my lord.
What was the cause? What is the cause of action?
He said that his salary was stopped in July 2013. Yes, my lord. He said the salary was...
So the cause of action is non-payment of salary.
Yes, my lord. He said his action is stopped. So that he said that his appointment was terminated. Meanwhile, we said no, his appointment is not terminated. That is our position. But he said his salary was stopped. Fact, and all the facts are before your lordship, my lord.
Cause of action, is it the stoppage of salary
or
termination of appointment?
It's a stoppage of salary, my lord, not termination of appointment. We are not even arguing. We are not saying our position is that his appointment subsists.
It's not your position. It is from his case that is the cipher cause of action.
Yes,
so from his own case,
my lord.
What is his cause of action?
Yes, that is why, my lord, he said in his claim, my lord, he said that salary was stopped in July 2013, my lord.
Okay.
He did not, yes, and he filed this case in 2025. That is our position, my lord.
Okay.
That is our position, my lord. And in the merit, my lord, he has not proved this case.
Just one. Let's say for a day. Okay. Is this case that I delivered judgment and they came and asked me to set it aside so that they...
Yes, as your lordship pleases.
Yes, sir.
Yes, sir.
Yes.
All right, thank you. Is that all? Is that all?
Yes, my lord. We have adopted to my lord.
Yes. Olayemi.
Yes, my lord, sir. Upon the service of the defendant's final written address, sir, the claimant filed his own final written address, which is deemed as properly filed and served this morning, sir. Well, the claimant's final written address was dated 18th March 2026 and filed on the 23rd March 2026. My lord, we adopt the final written address as argument in this case, and we urge your lordship to grant the claims of the claimants.
Yes, any address in adumbration?
All our opinion and our submissions are contained in a final written address. We don't have anything to add, sir.
Okay, maybe, but you will answer my question.
We
he said the matter is statute barred. What is your response?
My lord, our position is that it's not statute bar.
Why?
The law being cited by my learned friend, it's a state law, which deals with the law, stricto sensu. But in this case, my lord, National Industrial Court is a court of law as well as a court of equity. even before the claimant was sacked or was asked or was prevented from coming to work. He has been there. He has spent almost more than 10 years, which is his salary period for, he's a pensionable, he's already pensionable. And up to today, no pension, no salary. On this same month that he was prevented from coming to work, because they now agree that they did not sack him, that he was prevented from coming to work, they stopped his salary. And he had made every effort to ensure that they restore him back and his salary paid, but all to no avail. He had to go. I mean, we believe that it was in cahoots with the staff of the defendants.
What is your own course of action?
My own course of action is illegal sack and prevent not paying his salary. So we are not asking that his salary be paid.
Illegal sacking. Illegal sacking.
Yes, as companies.
When was he sacked?
Legal termination of his appointment.
Yes, illegal termination. When was his appointment terminated?
It was terminated in July 2013. And all
2013.
Along,
so
yes.
By all principles of laws, if your cause of action arose in 2013, what saves the cause of action up to 2025?
My Lord,
going by all principles of laws.
Yes, my Lord, sir. The cause of action did not arise in 2013. Because in 2018, the defendant staff wrote after
when was the matter filed?
It was filed in jail in 2025, January 2025.
So let's assume that the cause of action arose in 2013. Let's go by all the rules of limitation, including laches and acquiescence and every equitable defense. What would save the matter in 2025?
My Lord, what you say the matter is the labor law, my Lord, which is an act of the federal government. It has to do with the law, which the
labor law has no limitation. The labor law is not subservient to limitation law.
My Lord, this is right. It's a constitutional issue. It's right to collect his salary.
You see, because this thing is something we need to understand you. If you are conceding that your cause of action is unlawful sacking, and it was in 2013, and you filed the matter in 2025, you need to show us the law that saves the matter, isn't it?
But it works.
Give me his final written address.
The claimant can.
Yes. You have your final written address there?
Yes, my Lord.
Do you have your final written address there with you?
Yes, my Lord.
So you responded to the issue of statute bar in which paragraph and page? Thank God you have paginated your work.
Yes, sir. My Lord, they will refer to it in paragraphs 3.
At page what?
02. Page 5. Page 5. Page 5, sir.
Okay.
Page 5.
3.
Up to
Yes, so what's the summary of that response? Because I see you are
the summary.
You are making reference to Section 4(1)A of the Limitation Law of Ekiti State, and then you are making Public Officers Protection Act of the Laws of the Federation, Nigeria 2004, and you are making reference to Section 254C
Yes, which give the lordship the power
Yes.
to order for his payment of his entitlements.
Yes. So in
Sir.
what paragraph is the main argument that saves this action from application of the limitation law, or that puts this case outside the limitation law?
Well, the argument is that your lordship has no jurisdiction to hear this matter, that it is settled by. We are saying they are wrong, because your lordship has the power, and that's why we have cited those authorities, that even the law they are citing is a state law.
From counsel.
Yes,
This kind of argument usually gives somebody headache. The man says, I have no jurisdiction. The reason is that the matter is already statute barred.
yes, my lord.
And your argument you are hampering on, I have jurisdiction. Ordinarily, I have jurisdiction. But the man says it is statute barred. Your response, and I'm asking just a summary of your response,
Yes, sir.
should be on why the matter is not statute barred. And you are telling me why the matter is not statute barred is because I have jurisdiction.
Yes,
I'm trying to look at your argument. It is a long stretch kind of argument that I cannot pick the summary of the argument in any paragraph. And I ask you to open it and lead me. You are not helping me.
Yes, God places.
Hmm? The defendant has outrightly said, yes, your cause of action arose so time, and you filed it so time, it is statute barred. That is quite understandable because the limitation law says 3 months, isn't it? Now you will consider you didn't file within 3 months. So why is it safe? That's just the question I'm asking you, and we are talking too much grammar. Why is it safe?
My lord, what you are saying is that, with respect, sir, that the issue of 3 months, that he has vehemently argued, is not relevant to this case. 3 months has to do with the authorities of 3 months.
Is it the 3 months that is not relevant to this case or the limitation law?
It's not. This case is asking for the issue of 3 months. Does not even the limitation is not relevant to the limitation law.
Good.
It's
Why?
not relevant to it because
yes. Why?
The limitation.
Why is the limitation?
My lord, the limitation law has to do with the issue. It's not to do with the earning of salary. It's entitled. The claimant of position is that the claimant is entitled to his salary, even if he has been prevented from working. And we believe that up to the time of his retirement, he was still there. He still remained there and salary remained unpaid. So
if
you
had answered like this, then we know straight. Your answer is limitation law is not applicable because it's his salary he's asking for.
That's what places.
But that is another contradiction because I asked you the cause of action. You say it's termination.
No, my lord.
It was even the defendant that says the cause of action is non-payment of salary. But you are saying it's termination.
It is, sir. It is.
If it is termination,
yes, sir,
then the rule will a different rule will apply if your main cause of action is simply termination.
No, not at all, sir.
But a different rule apply if the cause of action is non-payment of salaries.
Let's go places.
So I will study the pleadings.
Let's go places, sir.
Study the entire case and the written addresses. At least it's why I ask you these questions is so that I'll get a glimpse of what I am going to see.
Let's go places.
Okay. I'll read everything.
I try your lordship.
Thank you.
Yes, sir.
Case adjourned communicated to parties.
As complices. Agree, sir.
Thank you very much. And we shall all leave the Zoom. We shall all leave the meeting. Come. Where do I press to leave? Okay. Yes.
Okay. Yeah, free. You man, I'm done.